You ever stop and think, where do our laws actually come from? I mean, they don't just pop into existence, right? Nope. They grow, they change, and really, they tell the story of a society. So today we're going to dive into the incredible evolution of India's legal system. It's a journey that takes us from straight-up personal revenge all the way to modern-day reform. Let's get into it.
Okay, so get this quote from Lord Macaulay back in 1833. It really gets to the heart of our whole story. He looked at India and saw, well, a total patchwork of laws and customs. It was kind of chaotic. And his big mission? To create something brand new, a system built on uniformity and, maybe most importantly, certainty. But to really get why this was so revolutionary, we've got to rewind and see what things were like before.
All right, here's our roadmap for this explainer. We'll start with how it all began, from revenge to rulers. Then we'll jump into the British legal blueprint. After that, we'll see how India adapted that inheritance, look at how modern law gets reformed, and finally, touch on the idea of law being in constant motion.
Okay, so let's start at the beginning. I mean, way, way back. Before you had courts, before you had law books, how did people handle justice? Well, it was a much, much more personal affair.
Yeah, you heard that right. The earliest form of criminal law was basically revenge. It was a system of what historians call self-redress. If someone wronged you, you and your family took matters into your own hands. An eye for an eye, literally. And you can imagine this often led to brutal retaliation, blood feuds that could go on for generations. It was pretty much anarchy.
But what's so fascinating is watching how this slowly started to change. So the first step away from pure revenge was compensation. Instead of a life for a life, maybe the two families would agree on a payment instead. But the real game changer was when the state finally stepped in. Rulers, using ancient legal texts like the Institutes of Manu, started to officially define what a crime actually was. And here's the kicker. When a criminal was fined, the money didn't go to the victim anymore. It went to the king's treasury. All of a sudden, justice wasn't a private family matter. It was a function of the state.
So this system of state justice, it evolved over hundreds of years. But by the time the British came into the picture, things had gotten, incredibly fragmented. And this fragmentation set the stage for probably the single biggest transformation in India's entire legal history, the Great Codification.
This timeline really paints a picture of the chaos and then the solution. So let's break this down. For a long time, justice in ancient India was guided by religious and customary laws, the Smritis. But fast forward to the 18th and 19th centuries, and the whole system was just a mess. You had the British presidencies in Bengal, Madras, and Bombay all passing their own different regulations. We're talking hundreds of them. It was all over the place. The big turning point came in 1833. The British Parliament created a single legislature for all of India. A year later, they gave Lord Macaulay the massive job of creating one single unified criminal code. And that project, years later, gave us the Indian Penal Code of 1860.
And you can totally see why this was so necessary, right? Imagine this. Macaulay described a system where, depending on who you were and where you were, the law was completely different. Hindus might be governed by one set of rules, from texts like Manu, while Muslims were governed by the Quran. Something that was perfectly legal in a big city could get you in trouble in a rural area. And court decisions, they could feel totally random. It was exactly this chaos, this lack of certainty, that Macaulay wanted to fix.
So the takeaway here is that the Charter Act of 1833 was so much more than just some political document. It was really the starting gun for one of the most ambitious legal projects in history. The goal was to take that messy, chaotic patchwork of laws and replace it with one single rulebook, the Indian Penal Code, or IPC, that applied to absolutely everyone.
All right, so fast forward to 1947. Independence. Now, India has a huge choice to make. Do you throw out all the old colonial laws and start from scratch? Or do you keep them and adapt them? Well, the new nation chose to adapt, and that started the long, long process of making this inherited system truly its own.
So yeah, India pretty much adopted the entire British legal framework, including the Indian Penal Code as its foundation. Now, on the one hand, this was great for stability and continuity. But, on the other hand, it meant a lot of the laws on the books were really products of a different era, made by a different government. So, the work of reform, it had to get started.
And here's a perfect, concrete example of what that adaptation looks like. The original IPC had a punishment called transportation for life. I mean, think about that. It's a total relic of the Colonial Era, right? They would literally ship convicts overseas. So after independence, that had to go. Through a series of amendments, transportation for life was officially replaced with imprisonment for life. It seems like a small change in wording, but it's actually really significant. It shows the new nation updating the law to fit its own new reality.
So, how does a country actually go about changing its laws today? Well, in India, one of the key engines for this kind of reform is the Law Commission. It's basically a body of experts that studies old laws, debates them, and then recommends changes to the government.
Let's take a look at a big one, the death penalty. Okay, so back in 1967, the Law Commission took a hard look at this. And in its report, it basically said that, given the circumstances and the crime rates at the time, India should keep capital punishment. They argued it was just too risky to get rid of it.
Okay, but now, let's jump forward in time, nearly 50 years later to 2015. The whole conversation has changed. The Law Commission starts a brand new, major re-examination of the death penalty. And this is such a perfect example of how law isn't set in stone. What seemed like a clear-cut decision in 1967 was suddenly up for serious debate, simply because society itself had changed so much.
Now check out this other case study. It's really fascinating. In 1993, the head of the Law Commission writes a confidential letter, and he sends it straight to the Prime Minister. In it, he flags a growing and absolutely horrific problem, the sale of women and children. He calls it a social evil and warns that the laws on the books just weren't enough to stop it. And I know what you're probably thinking. Wait a minute, wasn't selling a person already illegal? I mean, of course it was, right? Well, the reality was a little more complicated than that.
So the Commission found a huge loophole. See, the existing laws, sections 372 and 373 of the IPC, they were super specific. They only made it a crime to sell a minor for the purpose of prostitution, which of course is horrible, but it created this really dangerous gap in the law. What if a person was sold for something else, like forced labor? Under those very narrow laws, the traffickers could actually get away with it.
And this is where you really see the power of the Law Commission. They didn't just point out a problem, they came up with a clear solution. They actually drafted a whole new law, Section 373A. And this new section was designed to be way broader. It would make it illegal to buy or sell any person, no matter their age, for any purpose whatsoever. This was about more than just closing a loophole. It was about bringing the law in line with basic fundamental human rights.
And here's one more really big one. For more than 100 years, Section 309 of the IPC actually made it a crime to attempt suicide. But the Law Commission pushed to get rid of it, and their argument was powerful. They said that a suicide attempt isn't a crime that needs punishment. It's a sign of a deep mental health crisis that deserves treatment and care and compassion. And that right there is a huge shift in legal thinking, from punishment to empathy. So, when you put it all together, from private revenge all the way to the debates in the modern Law Commission, you see that the story of Indian law is just one of constant change, constant motion, and constant adaptation.
So let's recap the journey, right? It starts with personal revenge, which then becomes the job of the state. Then comes the British codification, which, despite its colonial origins, brought some order to the chaos. And ever since independence, modern India has been working to adapt that inherited law, changing everything from specific punishments to how we view deep social issues, all to better reflect its own evolving values.
And that kind of brings us to a final thought. We've just traced how law has always changed to reflect society. So it makes you wonder, doesn't it? What are the big debates we're having right now about technology, about society, about ethics that are planting the seeds for the laws of tomorrow? Because this story, as always, is still being written.